Good afternoon. Thank you for joining us again with IP attorney Matthew Grumbling. Hi, Matthew.
Hi, Julie. How are you today?
So last week we finished up on the patent series, and today is the kickoff of our trademark series. So today, Matthew's going to share with us trademark basics and what every entrepreneur should know. So Matthew, I'm going to go ahead and pass this over to you.
All right. Well, thank you, Julie. I don't expect this presentation to take very long. However, maybe that will give us some time to answer some questions, or maybe I can just ramble on at the end about some basic things about trademarks. Trademarks, I think, are even more important than patents in a lot of cases, and we'll talk a little bit about why I think that's the case. Most companies don't actually deal with patents unless they're heavily involved in technology, because their major offerings are either they're regionally specific, or they are or they have some differentiator based on quality or cost. And a trademark offers you a way to protect those differentiating factors of your business. So I thought we'd just kind of back up a little bit and remind ourselves what intellectual property is. That term intellectual property, I've always thought it's kind of misleading in a way. I tend to think of it as being abstract property, but I guess the intellectual, points to it's a matter of the mind, and so the term abstract also indicates that it's a matter of the mind. It's an idea or concept. But intellectual property it's another tool for protecting your business. And you invest in various tools for running your business, some hardware tools, say copiers, phones, and computers and whatnot, and as well as human tools. Intellectual property is another tool for protecting your business, and as a tool, it needs to be understood. It needs to be applied properly. More specifically, it's a tool for keeping others out of your business. It's a lot like an alarm system in a way. It's an right. You can exclude others from doing what your intellectual property covers. And the physical analogies I've already used one of them, but it's boundaries or fencing or walls around a property. Some abstract analogies, title deeds and leases are they're generally documents that memorialize some sort of property rights that people have, and rental agreements and things like that. These are analogies to intellectual property, and so are contracts. Now, we've talked about another type of IP, which is patents, and we kind of brushed up on trade secrets and copyrights. Today we're talking about trademark in particular, and we'll talk about more. We'll kind of go into these things in depth a little bit as we go through here. So these are some of the topics that we'll cover, and maybe not in this exact order, but we'll talk about what a trademark is and what they protect, and how they're acquired and maintained and lost. I think those are all three important aspects of trademarks. And then we'll talk a bit about federal trademark registration and how long they last and what do you need to do to keep them, and how much do they cost. So a trademark is any indicator of the source of a product or service. And the whole idea of a trademark is if you go back into medieval times, the guilds would, the trade guilds would actually have recognized indicators of it might be just a mark, that indicated that they were, a particular trade guild was responsible and had the, if you will, a monopoly on a particular thing, and these trademarks came to be accepted as being an important part of commerce because they perform a certain number of and I should say a certain number of functions. There are different types of marks. There are word marks. You probably recognize some of these. There are symbols. And then there are combinations. These are all trademarks that you can find on the web in various contexts. And then there are others. There are things like sounds, like Intel has their dun, 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 sound. And sorry about that if any of you have good hearing. It probably didn't sound very good, but and others in color. There was a famous case several years ago where a dry cleaner trademarked a color that was associated with their particular service. So these are all, and you'll notice here, color isn't always part of it. You'll see here in the Apple that that they don't have any color in this particular version, but they do in this version. And over here in Amazon, we have the orange on black, and over here we have orange on white. And so you can protect these trademarks in a variety of forms. The symbol with or without the word mark and things like that. And you might, if you're kind of up on these things, you might remember that back in the day, the Beatles had a recording studio called Apple. And when Apple Computers attempted to get into the business of selling music, there was a bit of a conflict there, and that had to be worked out. So these are all basically what a trademark is physically. It is something that's associated with your product, whether it's a word or a symbol or combination of those, or a sound or a color. What do they protect? Well, trademarks are indicators of source, as I talked about earlier. And as an indicator of source, the primary justification actually is under the Commerce Clause of the Constitution as a consumer protection device, and it's secondarily to protect businesses, but it protects consumers from being misled into buying one product thinking it to be another. So if you go to buy a Gucci bag and you pay hundreds of dollars for it, it would be very nice to know that it was actually made by Gucci and not by some knockoff artists. So that's the primary justification for it. Secondarily, it protects trademark owners, and really what you're protecting, aside from your profitability, is your goodwill. So there are actually two things you protect there: your upfront profits, but also your good name, because oftentimes those knockoffs aren't manufactured with the same degree of care and loving kindness that you put into your own products, and so that can undermine your reputation in the marketplace. And so the trademark law empowers you to enforce these trademarks against others who would copy your trademark and try to pass off their product as your product. So how are trademarks acquired? And we'll talk about how they're acquired, maintained, and lost. First off, they're acquired by their use in commerce. So if you make a product and then you attach a trademark to it, whether it's a word or a symbol or a combination thereof, particular color, whatever that trademark happens to be, and you use it in commerce for the first time, you've acquired it. Now, there is a requirement that you be the first. Now, if you're not the first, then your trademark can be usurped or canceled by the first user. But if you file a trademark registration, a federal trademark registration, there's a presumption that you have priority. And part of the reason there is a presumption there is that there will be a trademark search done in the federal trademark office, and that serves as prima facie evidence that you have priority in your use in commerce. It kind of underscores something else that I don't have covered in the slide, but it's fairly important to have a trademark search done before you even start working, because you don't know what somebody else has done out there. And there may be valid trademarks, there may be old, expired, or abandoned trademarks that you may want to take advantage of. There may be some that are being underutilized, and that you may be able to either license or purchase by assignment. How can you maintain them? Keep using them. You keep using them in commerce. For a federal trademark, it needs to be used in interstate commerce because it comes under the interstate commerce clause of the Constitution. You have to meet the statutory requirement, the legal requirement that it be used in interstate commerce. Common law trademarks, you keep them by just continuing to use them in commerce. And I haven't distinguished here between the federal and these, say, state or common law, local trademarks, but you can have a trademark that is not registered with the federal government. In fact, many states have a local trademark registration capability. The difference between them is scope, and I'll talk a little bit more about that later on. It's also important to know that federal trademarks, can be renewed from time to time. And so, in addition to continuing to use them in commerce, you can also re-up your subscription in a sense. How can they be lost? Well, in the federal system, proof of prior use by another user is one way to do that. And there are particular proceedings that are carried out in the United States Patent and Trademark Office, at the Trademark Trial and Appeal Board, where trademarks can be canceled. And basically, normally speaking, I'd say most of the time, it's because somebody else has used the trademark in commerce, and so that there's some prior user rights that they have. But there's also the possibility of abandoning a trademark once it's been established. There's a pretty famous case years ago where, and I believe it was the Shelby Cobra trademark was at least allegedly abandoned because it just hadn't been used in commerce. So every once in a while, you'll see these. You'll see trademark owners manufacture a certain number of products, put the name of their maybe formerly famous trademark on there, ship it interstate to somebody who buys it, and then they try to maintain it that way. Sometimes that works, and sometimes it doesn't. But this problem of abandonment by a trademark, I mean, it could be abandoned because the company went bankrupt, or it was acquired, and the acquirer just didn't care about that trademark, didn't want to put the money and the time into having another trademark out there. Although oftentimes in acquisitions, that's why there was an acquisition. You know, a lot of time you've seen a lot of consolidation, not in the last few years, but since I was a child, you've seen a huge amount of consolidation in various commodities like breakfast cereals. And the acquirer is you know, in fact, in a lot of consumer foods, where the whole reason that somebody buys a particular brand is to have the brand. You know, they don't really care what the product is. They know that there's value in the brand and that there will be a profit made. And you can see what the value is to these brands when you go to your grocery store and you look at the price differentials between, say, just to use an example, Kraft mayonnaise or you know, spread, and compare that to the store brand. And you can see that there's often quite a huge differential between them. Well, that margin there is profit to the brand owner, mostly. And they invest a lot of money in that, in maintaining those brands. And so they, you know, keep every dollar of that differential. They're reinvesting a lot of that money back into maintaining the brand. But that differential is pretty large. It makes it, you know, brand loyalty is a real thing. So if you work very hard to develop a brand loyalty, you don't want somebody to come along and undercut your costs and your prices. So the next thing I will cover here is what is trademark registration. Federal registration is an administrative process that allows you to enforce your trademark in federal district court or the ITC. So basically what you do is you file an application, very short. It's nothing near the complexity of a patent application, because all you really need to do is allege that you give a sample of your mark. If it's a word mark, you just the word typed out. It's a symbol, then a copy of the symbol. If it's a combination, then a combination. You can register. You should register all three of them separately, and then a trademark examiner at the patent office, who is a lawyer, will do a search and will determine whether, to the best of their ability, whether there's been any prior use of that, and if there has been a prior use, then there will be some back and forth with you, the applicant, to determine whether that is still ongoing. You may be able to prove that it's been abandoned or something like that. Provided that there isn't a prior user who has superior rights to that trademark, you would then get a registration. There's a requirement, again, that it be that the good or service that is trademarked be used in interstate commerce. So you either allege it up front that it is being used in interstate commerce and you provide your proof, let's say websites or something like that, where you're offering it for sale, or you can file with an intent to use. Maybe you haven't fully developed the product yet. You intend to use it in interstate commerce, and then maybe you're waiting to get your trademark registration done, or maybe for your patent to issue or something like that. And once you've met those, once you've gotten it on the market, you can send in proof to the patent and trademark office that it is being used in interstate commerce. When that's proved, then you have a valid trademark registration. I've always said that you can file an intent to use, and I've already said that. Now, if you fail to demonstrate actual use, even if you got a registration number, this will result in abandonment of your trademark. So you know, timing is kind of an issue here. You can file extensions, but you want to be pretty close to market before you file a trademark registration. It doesn't take long for them to work their way through the Patent and Trademark Office, much less than a year. Everything about trademark registration is cheaper and simpler than patent applications. You'll know pretty quickly, probably within a few months after filing, whether or not you're going to get pushback from the patent office, and what you're probably going to do about that. Should you register? Well, it kind of depends. And again, I'm talking about federal registration here. You can do local registration, and that's kind of a different thing. But some factors to consider in favor of registration are, will it be used in interstate commerce? Well, obviously, if it's not going to be used in interstate commerce, if it's always going to be fully local, then you can't apply for a federal registration. Another thing to consider is, how much time and money have you invested in your brand? How much of the value of your company is going to be a result of you're getting a brand recognition with your customers, and they're continuing to come back to you for fulfillment of whatever they bought that product or service for in the beginning. And there's advertising, and there's word of mouth and whatnot. And when you come right down to it, chances are, if you got a normal company, you've got a lot of time and money invested in your brand, and you want to protect that. You don't want everybody out there using your name to sell whatever the product is or service that you're selling. So, certainly if there's competition likely, you're going to think about it. Another reason, and I mentioned this before, but a valid trademark registration is prima facie evidence that you have priority. So let's say you're worried that somebody else may try to come to market with a similar product using a similar trademark. You may want to jump the gun and get that in there. You've got a piece of paper from the federal government. You have a presumption that you can prove up in court. Let's say you're working really hard to develop this trademark, and mostly your business is local for now, but you have dreams, maybe franchising or something like that. So you definitely want to try to drive a stake in the ground if you're thinking about franchising, and give yourself an opportunity to get that trademark throughout the United States. This is especially true if you're worried about a competitor maybe tarnishing your brand with bad products, or if they're out there competing, and maybe you could force them off, to quit using the trademark later on because you have priority. That may not be such a big deal, but what if they've so tarnished your brand by the time you get around to competing with them head to head, that now you feel like you need to change your trademark because your good name has been so besmirched. Now, against registration, well, if it's only going to be offered locally or in one state, you have no dreams of franchising, and you're really not worried about any sort of interstate commerce, then this is then why bother, right? These next two are kind of throwaways. They're like, when is it ever the case that there's little value in your brand, or that competition is unlikely? There will always be competition. Your brand is probably pretty valuable to you. So, again, I think what it's going to come down to is local versus national. If you're putting up a website, you're offering your product or service nationally, you should definitely think about trademark registration. So, on that matter, the cost for filing and the timeline, it takes about a year between filing a trademark registration application and grant eventually. That excludes an opposition period. If somebody opposes your trademark, it may take longer. And also, if you have to prove interstate commerce after you file, then let's say you haven't actually sold an interstate yet, but you intend to. Any extensions are going to take more time. And again, the costs they're relatively low compared to patents. Patents, it's odd to get into even a patent application for less than 10 grand. The costs are normally south of $2,000, and they can be even cheaper than that if everything goes smoothly through the patent office. It excludes, again, this excludes any opposition fees and extension fees. Obviously, if something goes south and there are problems to fix, then it's going to cost more. But just filing the application and probably filing one response to an inquiry by the trademark examiner, you're still going to be south of probably the most $3,000, something like that. How do you maintain them? Trademarks, unlike patents, which have a limited time, are essentially perpetual. And I always smile when I see I don't know I can't remember if it's the beginning or the end of Disney movies these days, but almost all of them have some little snippet of Steamboat Willie, which was the first Mickey Mouse cartoon ever made. And it's in black and white. He's whistling and he's steering a steamboat with the wheel. And I smile when I see that, because I know that this is their attempt to perpetualize Steamboat Willie as a trademark, because the copyright is going to expire eventually, and the company would dearly like to hang on to it as intellectual property of some sort. So they very cleverly kind of stuck it in there as a trademark for their. I don't know what they're up to, and I'm sure others are as well. And essentially, if that becomes a valid trademark for their goods and services, then it's essentially perpetual. There is a requirement that they be renewed every 10 years. But when you look at the value of these trademarks, it's a nominal cost. I mean, the real cost is just keeping track of those trademarks and making sure that the maintenance fees are paid, and having somebody engaged to track all of their trademarks and have them maintained. And like I said previously, trademarks can be lost by abandonment. They can be abandoned by neglect. They can be lost in say a bankruptcy where nobody purchases them out of bankruptcy and uses them again. They can be lost because by design, that whoever owns a trademark just decides it's not worth keeping up anymore. And that's the end of the presentation there. Again, I don't think it's too much to stress again that the trademarks, I think, are even more important than patents in most businesses' lives. And if you're concerned about, you should be concerned about two things. You should be concerned about protecting your own brand, but you should also be concerned about other people's brands and keeping track of those. And that will be a subject of a later presentation. All right. So that's everything.
Hey, well, thank you. It doesn't look like we have any questions right now, but as I state every week, we do record these webinars. So if you missed anything, You're welcome to go to the Supplies Economic Development YouTube channel and rewatch it. And also contact myself, or you can contact Matthew at any time with any questions. Thank you, and we'll see you again next week for the second part in our trademark series.
Thank you, Julie.